Attention, please. Good morning. Thank you for coming. We're going to begin this meeting for the Senate Public Safety Committee. We're going to begin, as we always do, with a word of prayer. Senator Payne, would you please open us up?
Certainly, Mr. Chairman. Let's pray. Heavenly Father, we come to you today and just thank you, Lord, for all the many blessings that you bestow upon us each and every day. Father, let us not take even the simple blessings for granted, but know they are gifts from you. Father, we just ask you to lead us and guide us and give us clear eyes and hearts of discernment as we do the work of the people in the state. Thank you, Father, for all your many blessings for us. In Jesus' name we pray. Amen.
Amen. Thank you. Good morning. As we call this meeting to order today, I first want to thank everyone that is here to either listen or testify. This is the second meeting in a series of meetings of which we'll be gathering information in order to make sure we're fully informed and come up with actionable and tangible items that we can add as either legislation and or budget items to help out from the state level. However, our work does not stop at the state level because we know that criminals tend to operate across all jurisdictions and all lines. So it takes a team effort to resolve the problem that we face today, and it begins certainly with our cities, counties, our schools, our state and federal government. However, there's nothing that we can do here that is going to eliminate the personal responsibility that people need to take in this world right now. Both themselves individually, as well as their parents, their grandparents, their aunts, their uncles, their friends, their children, their houses of worship, and other community organizations. So as we continue this process, I'm going to ask everyone to come together and please do the right thing that we can keep people both physically safe and also with the perception of safety around them. In this first meeting that we had a few weeks ago, we heard from the GBI, the Georgia State Patrol, the Sheriff's Association, the Chiefs Association, as well as many members of their association, as well as the Fulton Solicitor. We've got a very full docket today, and I'm going to ask everyone to please be very concise. And I'm also going to ask our committee members that if we keep our questions shorter and we can do follow-ups, because we got to get through a lot of folks, and we're going to get kicked out of this room at noon. We are going to have another meeting coming up when we return to the special legislative session on that first day on Wednesday in November. We'll be hearing from the Fulton County District Attorney then, from the Department of Corrections, from the Department of Community Supervision, from the Fraternal Order of Police, the Atlanta Police Foundation, and Pardons and Paroles. If you're not on that list and you'd like to talk, please come see myself or Miss Allie Farmer next to me, and we will discuss the agenda for that meeting as well. We are beginning to assemble a list, though, of the items that we're hearing, and we appreciate your recommendations. And today we're looking for candor, respect, and transparency. If something's broken, it's okay to say it's broken. We're not going to offend anybody here. Likewise, if something's working good, we want to hear that. But we're looking for actionable things to move forward. Last thing I want to say, and this is how I opened up the last meeting. Crime impacts our entire state, whether it's happening in Atlanta, it's happening in Augusta, it's happening in Columbus, it's happening in Valdosta. However, this is our capital city, and so goes Atlanta. So goes the entire state of Georgia. And we're seeing a huge uptick that's impacting us here, as well as other parts of the state. I use this example that I was up right after Labor Day in Nashville, Tennessee. And after having dinner with a group of people, I walked around that city, and it was beautiful. It was clean. It looked good. Heck, it even smelled good. I came home and I walked out of the 191 building where my business office is, and the smell was horrific. There's graffiti everywhere. There is garbage blowing down the road. There were people sleeping everywhere. There were aggressive panhandlers. And that's just unacceptable. As I drove and I left that night, I passed more tents than I could count. We need to help folks that need help, and we need to make sure that we're giving them the support they need to. But we need to literally and figuratively clean up Atlanta. And I want to take a moment to thank the folks of the city of Atlanta who heard that, and I had a couple of discussions, because it has already been improving. So I want to give a personal thank you to that. There's still a lot of work to be done. But we've talked many times about what the perception is, and the perception has to be one of safety. Okay, so before we begin the meeting, I want to thank the committee members, and I want to give a very special thank you to Governor Brian Kemp. The governor has been engaged in this topic, has been helping to create task force through our heroes at the Georgia State Patrol and other groups with the GBI, and continues to walk in lockstep to support our public safety and citizens. We're going to begin with Jeff Hamling today. If you'd come up, Jeff, I want to thank you for being moved off the agenda when we were running over last time. And again, if you could keep your comments clear and concise for timing, I'd appreciate that.
Thank you, Mr. Chairman. Not the first time I've been dissed on a date, so don't worry about it. Jeff Hamling, I'm here representing the Georgia Association of Professional Bondsmen. Got a PowerPoint. I'm going to throw a lot of data at you, and I'm going to try to do it really quick. Tell you a little bit about some of the data we've found, mainly in Fulton County. Starting off, go to slide 2, tell you a little bit about a signature bond. And I'm not going to be the expert. I'm not an attorney. I play one here at the Capitol. But signature bonds are a type of bond that allows judges and prosecutors to release offenders by signing court documents promising to return for their court date. Confusingly, while signature bonds are assigned a bond amount, no collateral or surety is assigned to this bond. And when I say you signed a bond amount, you'll see $45,000 signature bond. There is no collateral, there is no surety posted on that bond. The original intent was for low-level, nonviolent, somebody who's an upstanding member of the community is released on a signature bond because there's no threat to not return to court. So, next slide. The reason we started looking at the data, and Senator Robertson can attest to this, he had an incident in Columbus where an individual was charged with a murder, was released on a signature bond, didn't come back, failed to appear for court when he was supposed to, and then when the police pulled him over, he was, I think he hit 2 police cars and went on a high-speed chase. So Senator Robertson asked me if this was a problem, and I said, we are seeing this as a big problem in certain jurisdictions. Mainly Fulton, some in Athens, Columbus, DeKalb, Clayton, and a number of others where we have seen an increased use of signature bonds versus secured bail. So next slide. So in Senate Bill 402 prevented, sorry, go back one. So it defined an unsecured judicial release. So this was a new term that shows that you can't put a dollar amount on a signature bond if it's not secured. So we redefine that as unsecured judicial release, which is what it is. Somebody's been released without security on their and saying they're going to come back to court. Prohibited the assignment of a dollar amount on that signature bond. Next slide. And then certain offenses were mandated to receive secure bond. And I want to be clear when I say secure bond. Nothing prevents the court from issuing a $1 bond, a 1 penny bond. Any dollar amount needs to be secured on one of these offenses, this page and the next slide as well. You can see these are violent, not low-level offenses that we feel, and I think many members of the community feel that should be required to receive secure bail. The next slide.
So if you could just go back one moment.
Yeah.
I don't want to interrupt your slide presentation.
Go ahead.
This is really important. What we're talking about is not someone who is jaywalking. We're not talking someone who is picked up with a small amount of a narcotic that was not selling it, et cetera. This is for violent folks who are committing some of the most serious crimes.
Correct.
Okay,
Yes.
Thank you.
And then lastly, next slide there, you'll see define who is and isn't eligible for an unsecured judicial release, and says that an elected judge or judge sitting by designation has to be the one that is the one issuing those orders. So when I talked about the data, when we were hired by the industry a couple years ago, they told me this is a problem. I said, well, we can say it's a problem, but without the data, we're really just telling everybody it's a problem and we have nothing to back it up. So we started compiling the data. And I've actually put all the data right here in these 2 books you'll see in front of you. They're pretty big. So if anybody says, oh, well, the bail bondsman put that together, Everything's in there, and you're free to fact check it and see that it's accurate. So go to the next slide here. So this is a summary of 4.5 years of data that we collected in Fulton County. As I said, it's not just Fulton. I don't want to pick on Fulton, but I think what we are seeing here today in the city of Atlanta and Fulton County is indicative of a lot of this data. So these are the people, the number of defendants released on unsecured bonds, which is a signature bond, or pretrial release, and then the total number of offenses, and then the dollar amount that was assigned to those signature bonds, which adds up to $232 million. I say that amount because, to my knowledge, and I'd love to hear from some members of the judiciary, we're not aware if that money is ever collected if those individuals don't show up to court. I don't know if that's incorrect, but we have not been able to ascertain that. That shows you some of the counts: murder, gangs, family violence, rape, theft, failure to appear, drug possessions, entering auto, possession of a firearm by a convicted felon. Next slide. So as part of the data, I said we can show all this, but if there's no correlation to cash bail and a failure to appear, we're really not making any sense. So what we had to do was do individual searches of every arrest in Fulton County, find out if it was either secured or unsecured, and then correlate that with the Fulton County court system to see if that person did indeed show back up for court. You'll see 2017, 2018, that was roughly around 30, 1 out of 3. The reason 2019, 2020, and 2021 are so low or lower, you have a number of open cases. That's part of that case backlog that we're talking about. I would venture to say that as time goes on, you will see those numbers rise and probably rise more in line with the 1 out of 3. Next slide. This is this is hard to see, but this is the breakdown of the offenses by year. Those in orange are bail-restricted offenses. So beginning of this year, January 1, 2021, once Senator Robertson's Senate Bill 402 went into effect, those offenses are no longer eligible to receive an unsecured judicial release. They have to receive a secured bond. We are continuing to see some of those offenses released on unsecured judicial release. I will say it's gotten a lot better. I think there has been certain improvement, definitely, but we continue to see that being a problem.
Jeff, real quick,
Yep.
I would like as a follow-up for our committee 2 things. One, a copy of the presentation that we can go into detail, but I'd like to get a list of who is not following Senator Robertson's law.
Yep,
Thank
no
you.
problem. Next slide is, again, some of these offenses. Again, orange is bail restricted. And next slide, again, same thing. Kind of on your point there, the next slide kind of describes the releases by judge, and we basically broke this down between elected judge and an appointed judge. An appointed judge most times is a magistrate judge appointed by the chief magistrate judge, which is an elected position. The chief magistrate is elected, and they appoint judges at the magistrate level, and so you will see the vast majority of bail-restricted offenses that were released on an unsecured judicial release. That number is 440, and this is just since the beginning of this year. So this is just 2021. And then you'll see your percentage, 93% versus 6% by elected judges. Next slide. So this is an interesting data that actually the city of Atlanta has put together. The city of Atlanta went to a no cash bail system for municipal violations about 3 years ago, and you'll see if you kind of click through the slides here what they found in a report that was issued just recently, just earlier this year. Next slide. Basically, the failure to appears have doubled since that went into effect. And 1 in 3 have been seen to reoffend on those municipal violations. Kind of go next slide. It shows the 1 in 3. Keep going. That's the failure to appears that have doubled. Next slide. And then that's the 1 in 3 that are reoffending. Next slide. Lastly, I'll just leave you a couple of examples. I don't know if this will play. This is a quick video, 1 minute. I'll let you hear this. Hopefully it works. Shout out to 11 Alive.
Well, new tonight, police and the Fulton County DA have a message for judges. Step up. This comes after police arrested a second suspect in a shooting near Clark Atlanta University.
Now, officers say the gunman had a long rap sheet, which includes getting out on bond for another shooting. Hope Ford explains why the DA wants the court system to change.
I believe that it is that system that is at fault.
Just happened, bro? This shooting should never have taken place. We are very strong in our position that our court systems need to stand up, and we need to do better with this.
Ahmad Coleman is one of two suspects in the Atlanta Clark University shooting, and records show he was already on bond for shooting up an apartment complex with an assault rifle 2 days in a row back in April. No one was hurt in this shooting, but Coleman received 22 charges.
When this matter came up for bond, we asked the judge not to let him out.
But the judge did, on a $120,000 bond with the conditions of staying with his mother, maintaining a 7 p.m. to 7 a.m. curfew, and not possessing a gun.
This has happened over and over in our system.
A similar situation revealed itself in a murder case in July last year. Christian Broder was killed after.
So you can go to the next slide, and you see those charges on the bond order. That was the first incident when he fired the AK-47 into an apartment complex 2 days in a row, 2 consecutive days. Was not arrested at that time for that, and then later found arrested, released on a $120,000 pretrial release. You can go to the next slide, and that'll show that. $120,000 pretrial. Next slide shows those conditions. Defendant is not to possess a firearm. Next slide. And then after that, 5 months later, he went down to Clark Atlanta and actually shot 4 college students at a block party at the university. Last example, Athens Clark. This is a recent one. Individual was on campus and robbed 2 young ladies, 2 UGA students. One of them was raped. Next slide shows kind of details of that. Next slide shows the signature bond that he was currently on in Athens, Clark County for, I believe it was family violence. You can barely see it. Family violence, criminal trespass, a couple other charges there. That is it, Mr. Chairman. I'm happy to take any questions if you have any. I went fast.
Well, I appreciate that. And we were trying to keep on schedule, so we thank you for your brevity. This is important information. As mentioned, we're going to get a copy of both this presentation to all the committee members as well as the follow-up on who might not be following the law. We want to make sure that that's addressed, obviously.
And Mr. Chairman, I'm going to leave those books in your office, so anybody who wants to come look at them, they're happy to do so.
Very good. Okay. Any brief questions or comments from the committee members? Senator C. Let's use the microphone if you could, please.
I will. Let me do this too. When I see this, the first thing goes to my mind is he needs help, not released. He needs help. Are they doing any of that in the system once you get in the system? It just blowing my mind that 2 days in a row and then he goes to jail and then he get out. I don't care if it's $500,000, you know. You let them out and they doing the same thing. Where is the help? Because that is not the mindset when you can pull the trigger multiple times in a neighborhood that he obviously know about. I'm at a loss for words. But if you can address it, you can. And if you
I think
can't,
there's some folks here who can tell you more about the programs that they do use for help than I can.
Very good. All right. Yes. Senator Jackson.
Thank you for your presentation. I just want to be clear. So you began the presentation talking about unsecured signature bonds. The story that you showed us from the AUC, that gentleman was released on a secured bond. Is that correct?
No.
You're saying it was 120 unsecured signature bond.
Pre-trial, yeah.
It was a signature bond.
Yes.
Okay. Thank you.
$120,000 signature bond.
That's fine.
Pre-trial.
Right. All right. Thank you so much. Appreciate your time. We're going to go a little out of order here. I'm going to ask our Atlanta Police Chief, Chief Bryant, would you come up next, please? And I believe you're going to bring a little backup with you. As Chief's coming up to take the podium, I want to say thank you to him and to the officers who will hit you leads. It was not too long ago that the police chief, the former of Atlanta, former district attorney and former sheriff, couldn't sit in the same room together and have a conversation. But we have 3 people now that are not only taking a strong leadership position, but they are working together not just with the folks that in the immediate area, but they're working with all the surrounding agencies, whether they be in the other cities, counties, or states. So I appreciate your leadership, sir, and we'll turn it over to you.
Well, thank you, Mr. Chair. And to that point, our relationship clearly goes to our partnership with the Georgia State Patrol, the GBI, our federal partners as well, who we work with on a daily basis and have a strong working relationship. And I think it is that type of partnership that have allowed us to improve on a number of things that we're doing in the city of Atlanta. But before I go, I'll turn it over to the city's Chief Operating Officer, John King.
Thank you, Chairman, and thank you, members of the committee, for the opportunity for Chief Bryant and I to speak with you all today. Addressing violent crime continues to be a top priority and continues to be a challenge. Homicides and aggravated assaults are specific areas of concern because while our overall Part 1 crime is down compared to 2019, homicides and aggravated assaults remain higher. We greatly appreciate the hard work and leadership of the Atlanta Police Department each and every day. Today, certainly an example of that, to aggressively pursue solutions. We work to ensure that all of our city agencies and all possible partners support their efforts to address crime. And as mentioned, the mayor identified reducing crime as our top priority this year, including a budget increase of 15% for public safety and a commitment of American Rescue Plan funds to public safety initiatives. And today I'm just going to briefly highlight a few of our priorities and initiatives, and then I'll let Chief Bryant discuss some additional detail on our actions and some of the data. First, one of our top priorities is hiring additional police officers, as it is for many agencies across the state. This is a highly competitive hiring environment for law enforcement, but we've taken actions to improve our processes and offer a leading compensation package and competitive incentives. These efforts have made a proven difference as we have increased our hiring rates and are on track to meet or exceed our annual hiring targets. Second, another top priority is the expansion of our Operation Shield camera network. We set a goal to expand the network by 250 cameras by December of this year. We will exceed this goal, and we've already funded over 250 additional cameras. These cameras play an important role in our ability to deter and respond to crime. And then finally, I want to mention we had a anti-violence advisory council that the mayor convened, and that advisory council was part of our ongoing efforts to review, to learn, to adapt and improve how we address the challenge of violent crime. The advisory council was composed of diverse representatives from the business world, our community, law enforcement, and with input from leading experts in the field of violence reduction. Overall, their recommendations provided clear guidance on ways to further coordinate, focus, and invest in key violence reduction initiatives. This includes focused investment in community-based violence interventions, which have proven to be effective at breaking the cycle of retaliatory violence, and working with communities on enforcement and non-enforcement related actions. Lastly, the recommendation from the council also included expanding and further focusing on our efforts to address repeat offenders. This is a coordinated effort with the county's district attorney's office, county sheriff's office, and the Georgia Department of Community Supervision. And we greatly appreciate the partnership and support from many of the federal, state, and local organizations who are working with us to address violent crime. These are a few of the key investments that we're making, and certainly appreciate the support that we have and look forward to receiving continued support from the state on these initiatives. Now I'll turn it over to Chief Bryant to talk about some of the additional detail of the work that we're doing.
Thanks, John. To acknowledge the works from the mayor's office and the partnerships that we have, we now go to, well, what has it done? So at the beginning of the year, clearly we saw that our crime numbers were dramatically up. We implemented a number of plans. We implemented a plan immediately in partnership with our federal, state, and local partners. But our most aggressive plan took place over the summer, where we recognized that we would see the most increases in crime numbers. But thankfully, what we did see was those numbers begin to drop down dramatically from where we started the summer to where we are now. Our summer plan began somewhere around May of right after Memorial Day. Our murder rate at that particular time was 63% above the year before. We're now at 15%. And continuing to see those numbers go down. Our rape numbers at 108% over last year. We're now 67% over, and we're starting to see that and those numbers come down. Our robbery numbers were 2% over, and now we're at 4% under. Our aggravated assault numbers were at 29%. That number has dropped to 14%. Our burglary numbers were at negative 34%, which means we were under. We're still under at 29%. The larceny from auto is the only, larceny from autos was at 27% and is at 18%, meaning we are still seeing reductions in those numbers. The only number that we have seen an increase and have not been able to stabilize is larcenies, which are general thefts, and which makes it much more difficult. We attribute a theft that if you left your pen on the desk and I took it, that's considered a larceny. And then auto theft, which continue to be challenging, but we're also seeing that number drop from 36% to 13%. And so with those type of strategies, we continue to see these numbers go down every single week. We still have a long way to go, but again, it's the partnership, the strategies, the assistance that we've received from our partners, as well as the mayor's office. I think that has contributed to us seeing these numbers go down and will continue to go down. Additionally, I think John spoke about where we are as it relates to our hiring and recruiting. We are one of the few departments that are doing pretty well. I knock on wood as it relates to it. In my conversation with many other departments, as I talk to different police departments throughout this state, as well throughout our country, everyone is struggling as it relates to crime as well as recruitment. But we are seeing the tides turn here in the city of Atlanta. And so I attribute that to the men and women of the Atlanta Police Department, and again, to our partnership. I was just out yesterday. Oddly enough, I had the opportunity to reach out to Chris Wright, and I was just acknowledging the partnership that we have. Chris and I talk on a regular basis, and I know that we have Colonel Lamb and Colonel Hitchens here with us as well, who I generally have to buy lunch for on a regular basis as well. But I was acknowledging the work that we were doing and the men and women of Georgia State Patrol and Atlanta Police as I responded to a call in Southwest Atlanta. And what surprised me was, as I stated, the relationship that we have is I can pick up the phone and talk to these guys on a regular basis, but seeing our men and women that were on the ground, on the streets, the relationship that they had, the enthusiasm that they had in responding to a situation and resolving it was really to be commended, and that's what I was reaching out to the Colonel about on yesterday. And so, and then lastly, I think it's important that people understand where we are. Numbers can tell you a number of things, and I tell the team all the time that we have two jobs. One, to address true crime, and then to address the perception of crime. The numbers dictate where we are. We're 12% under where we were in the most stabilized year of 2019. That means we cut crime 13%. That's unusual. The areas that we continue to have, as John stated, and is in homicide and aggravated assaults. That's what we're seeing throughout our country. Those are the numbers that we saw and throughout the state and in the metro region. Those numbers we saw spike right after COVID, and no one has an answer to why. In every conversation, every group that I've been in, The question is why we're seeing it. We just don't know. What we do know is the level of response that we have. The men and women of our police department are committed to reducing it. And with that being said, I open myself up to whatever questions you may have.
Chief, thank you very much. Appreciate both your comments. Two quick questions for me first. What is the total number of officers you have today, and what is the optimal number that you need to protect the city?
So our authorized strength is about 2,042. Okay. We're sitting at 1,711. That's the number that I gave the mayor just recently. Minus 80 out of that 1,711, 85 are recruits that are going through our police academy, either currently or waiting to go into the police academy. Right now. So, and now we're hiring. We're, as John stated, aggressively hiring, and will appear to come over our recruitment numbers by the end of the year.
And Chief, if you could wave your magic wand and say this would be the optimal total number of police that you would have at your disposal, what would that number be?
I wish that I could give you a solid number. I could tell you that the metro region of Atlanta is much different than many other locations because we have so many different events. We have to deal with civil unrest, different than any other location, so it differs. I would say, just speculating, that number would be above the 2,000, our authorized strength. But I believe, again, we're able to manage very well with the partnerships that we continue to leverage with our state and federal partners.
Thank you. One last question. How is the morale for the men and women under your command?
You know, I did a briefing this morning, and sadly we had to deal with an incident that our officers responded to quite quickly, but engaged it and terminated that incident quite quickly. And this is something that we see every day, every single day. Our attrition has stabilized, and so we're not seeing officers leave at the same rate that we did last year. I saw the briefing from Chicago, and they are still having that problem with attrition. We're not in the city of Atlanta. Our retirement is back to normal. We have officers trying to come back to our police department. I just had a conversation with an individual on 2 days ago, his willingness to come back to the Atlanta Police Department. So I think the morale is getting improved, and it's always going to, I heard a study just recently that said 82% of the people that are questioning about their morale and enthusiasm dislike their job. I thought that was a crazy number, but it was 82%. I think that we're above that. I think that our numbers of the men and women that are enthusiastic about coming to work is improving, and it's a testament to what I saw yesterday in the partnership with Georgia State Patrol and our officers out on the street, and what we saw this morning.
Very good. Questions from the committee members? Senator Robertson.
First of all, I want to thank you, Chief, for coming in and speaking to us this morning. I know that you've been under quite a bit of pressure over the last couple of years, and I respect that and appreciate that. And got a couple of questions. And either Chief or John, whichever one feels the need to. John, you stated overall Part 1 crimes are down. What you're doing is you're taking the average of all Part 1 crimes and factoring those in and coming up with a percentage overall. Is that correct?
Yeah, I can speak to that. So what we do, we look at Part 1 crimes and we compare them, in the city of Atlanta, we compare them from 7-day, 28-day, year-to-date, and year to 2019. And so we take the average of what we had the year before and subtract it, and that shows us where we are tracking year to year. But we also track the 28-day, which I think is a better measurement because it allows you to see what initiatives you put in place 28 days, 30 days ago, and see how effective it is today.
Thank you, Chief. A couple of follow-ups.
Please.
Now, the crime drop of 13% factors in the drastic drop in burglaries. Is that correct?
That's correct.
Okay. Would it be true to say that burglaries, the vast majority of burglaries, are committed during the daytime?
That's correct.
Yeah. So in the pandemic, when the vast majority of our citizens are working from home or school's not in or doing virtual school or stuff like that, homes being more occupied would also be a driving factor to less burglaries, correct?
That's correct.
Yeah. So while I think that's great, and you touched on something I think that gets lost a lot of times, crime goes up during the summer.
It does.
I mean, it's a phenomenon that's been going on since the beginning of time because of something called summer break from school.
That's correct.
So the crime drops, as you were talking about moving through your, I think the initiative started in May.
Yes.
And moving forward, did you notice as you move closer and closer to August, September, that those numbers were dropping?
Yes.
And so do you think a part of that could be attributed to the fact that some teenagers were rolling back into the school process or getting back involved in the education side of their lives and not having as much free time out on the streets to find things to get involved in?
So partially.
Okay.
Well, one of the things that we generally see these numbers spike throughout the summer. But our numbers begin to drop continuously. There are many different variables that play into why we see crime drop and increase during a particular time. It could be the weather, cold snaps, rainy days, a number of things, presence of police officers, all of those things play. What we were able to see, and that's one of the reasons I think that is important when I say we track the 28-day, is that we see what's happening over a period of time as opposed to just one time. So even in May, and when we implemented this program, we started to see those numbers come down throughout the summer. In August, one of the things that we generally see is those numbers continue to spike up. We haven't seen them start to rise on it. They continue to go down.
Okay, thank you, Chief. And on the recruiting and everything, have you removed any disqualifiers that were there previous before, say, 2019, as far as an attempt to bring more people on board?
Absolutely not.
Okay.
One of the things that we did was work with the mayor's office to make sure that we had the right personnel and the right technology daily, and reviewing with my office and John King's office to make sure that we are continuing to hit the matrix that have been set before us. And then when we find that there's something that is clogging our system, we immediately work on it aggressively to make sure that we can unclog that and continue to get the candidates we need to be police officers.
Well, Chief, I spent over 30 years as a law enforcement officer in this state, and I'll tell you, come from a fairly large sheriff's office, I've never been more impressed by a training facility than the old training facility y'all had. So I can only imagine what the new one's going to be. And not necessarily with the facilities was I impressed, but with the quality of training and the quality of staff that you had there. Because I think when we start talking about police reform, a lot of times it starts in the classroom and in the training and in the recruitment and in not removing disqualifiers, but adding it, making it tougher. I think you'll look in the United States military and find that the Marine Corps rarely has a shortage, yet they hold the highest standard for an individual to come on. And so the training facilities that y'all have had in the past, and I can only imagine what your vision is for the future in building the new training facilities, I think things will only get better, and I do appreciate that. And my last thing is, as far as the homicides go, as I travel around, a lot of people say, well, murder is the one crime that you can't prevent. Well, and that's not true. If we're talking about domestic violence and things like that, maybe so. What goes on inside the house, we can't. But when we deal with murders related to drugs and gangs, the solution to that has worked throughout time has always been aggressive enforcement of Title 16s, Title 40s, and going out there and then having a strong internal affairs division to investigate the complaints made against the officers, which we know that well over 98 to 99% of those are going to be unfounded. So as far as the murders that you're currently experienced or have experienced in Atlanta so far, do you see the vast majority of those related to drugs and gangs? And if so, what percentage of those left over do you see more related to domestic violence?
So right now, and I'm glad you asked that question. Right now, the number one issue that we see is conflict resolution. That's two people who, for whatever reason, got into an argument and one decided to pull a gun and shoot the other, or if not both. Our number two category is domestic violence. That's our number two. Gangs and drugs are number three. So in that ranking order, right now we are seeing drugs slightly increase as it relates to it. So it may, by the end of the year, outpace our domestic violence, but that's not where we are right now. We are very aggressive as it relates to how we are addressing our homicide rates by doing different things. One of the things we recognize is, it's interesting, is most gang members have a girlfriend or boyfriend, whatever the case may be. And if they're violating crimes outside of that, they're violating crimes inside that relationship. And so we created a domestic violence unit to address them earlier before they can get out on these streets, as well as to be able to get information as to what the other criminal elements that they may be involved in. And so I think that has really helped us out tremendously. But I'd be remiss if I did not speak to us partnering with the FBI and our other federal partners in creating Operation Phoenix. Operation Phoenix gave us the ability to take some of our most violent offenders off of the street and put them in the federal system immediately. And we think that this has helped us in seeing our numbers come down in the city of Atlanta.
Chief, I appreciate you answering the questions, and I can only imagine how many defense attorneys tomorrow are going to start using the defense of conflict resolution involved when their clients use violence against somebody. That's great, but I do appreciate it. Thank you.
Thank you. Any other questions? Senator C.
Not a question, but a comment. I just want to thank you all for working together. I mean, I was around when everybody had lines, they stop at a line and pursuit with somewhere else and that kind of thing. Working together is going to make Georgia a much safer place to live. So thank you.
Well, ma'am, one of the things that you'll continue to hear me say is public safety is the responsibility of the public. It is not just the police. Our job is to do law enforcement, but the public safety is all our responsibility. And the more that we are engaged in it, the safer our communities will be.
Thank you. Other questions? Chief, John, thank you so much again for what you're doing and continue to do, and we look forward to following up with you.
Thank you so much.
All right. Next, I'm going to ask Pete Skandalakis to come up with the prosecuting attorneys. And Pete, I'm going to ask you for timing's sake to make sure that you speak briefly. Leave a couple minutes for questions, then we're going to dedicate the entire second half of the meeting to our esteemed judges, your honors. And at that time, I'm going to ask all of you to just come up and take the 7 seats and 7 of you here so we can have you together. Pete, go ahead.
Yes, sir. I'll be as brief as possible. Just as a personal introduction, my name is Pete Skandalakis. I'm the Executive Director for the Prosecuting Attorneys Council. The Prosecuting Attorneys Council is a small state agency. We manage the fiscal affairs of state-paid DAs. We also have 10 attorneys that work for the PAC, as well as 2 investigators, a victim advocate, and a training division. Prior to that, I was the elected DA for 25 years in the Coweta Judicial Circuit. I was an ADA for 7 years prior to that, and I'm most proud of the fact that I'm a triple dog. I went to the University of Georgia, got my undergraduate degree, my master's degree, and my law degree. Finally had to get a real job, and got out and got a job. Go Dogs, absolutely. A little known fact about me that I'll share with y'all is that I was raised right here in Atlanta, Georgia. We had a house here on North Avenue. I attended Highland Avenue Elementary School. My father ran a package store on Edgewood Avenue. I attended the Greek Orthodox Church, which was on Pryor Street. And so I was raised here in Atlanta and then went off to the University of Georgia. In fact, our house was right close to, just about a block away from Manuel's Tavern, which many of our electeds now frequent at times just to have meetings. That's what I hear.
Strategy meetings.
That's what I hear. Okay. I understand that you're focusing on crime in Atlanta, but as you well know, Mr. Chairman and members of this committee, this has been across the state. As I've surveyed DAs and talked to DAs, all of us are seeing an increase in violent crimes. All of us are seeing an increase in homicides as well as other types of crimes. So this is affecting all of us. But I understand what we're doing here, and I understand what you're looking for, so I will try to be as brief as possible. Everyone wants safe streets, safe schools, safe neighborhoods, and we do that by aggressively enforcing the laws with a professional and dedicated police force. Unlike any other market or any other industry, the criminal justice system is labor intensive. You have to have patrol officers out on the street. You have to have well-trained professional patrol officers. And when I started almost 40 years ago, the level of training for a lot of departments is a lot different than it is today. So we have some of the most dedicated professional law enforcement officers I've ever dealt with. But you have to have those officers patrolling the street. Second of all, you have to have detectives and investigators working those crimes, filing those reports with district attorneys and solicitor generals. So this is labor intensive. Then you have to have dedicated prosecutors, professional prosecutors who can screen the cases and decide where those cases go. Does the case get dismissed? Does the case get to a pretrial diversion? Does the case get to court? You have to have those type of professionals. And additionally, you have to have professional public defenders. You have to have people who can look at a case very quickly and make a decision whether or not this case can be pled out. Does it have to go to jury trial? Is there some other avenue that you can address the case? And of course, all this puts pressure on the criminal justice system and the courts when the cases come in. So one of the things that I think is important to note is we've got to invest in these places where cases come into the system. If you think about the criminal justice system, it's like a huge funnel. You have a number of arrests based upon probable cause. But as those cases come through, those cases have to be filtered, and they have to be sent down a track that either takes them one avenue to another. And if I can put it, my experience, we typically deal with three types of individuals. We deal with those types of individuals who come into the criminal justice system because they've done something dumb or they've done something stupid. And usually you can get their attention, and you may get their attention through just holding that warrant. For example, prior to there being even pretrial diversion programs or anything of that nature, what we would do if we had a first-time offender, particularly a young first-time offender, we would bring that person into the office and we would say, look, it was pretty stupid for you to go into a public restroom and break up the toilet, okay? That's a felony because it's state government property. So this is what we're going to do. You're going to pay the state back, you're going to pay the rec department back, and we're going to hold this warrant out for about a year. And and you're also going to write a letter of apology to the rec department. And after you do that, if you stay clean, we're going to dismiss this warrant. So we would dismiss that warrant. So you also have offenders that you can dismiss warrants before the case gets to court. You can put them in a pretrial diversion center, pretrial diversion program. If that doesn't work, you can take those same individuals. They can get first offender. They can go to an accountability court. They can go, if that doesn't work, you always have NOLO. If it's a drug case, you have conditional discharge, and then you have first offender. So you can give people a number of opportunities to get their act straight, and hopefully those people will not come back into the system. But then you have what the chief was talking about, and I think Chief Bryant has done a great job. I've heard him speak a number of times, and even at town hall meetings, so I think he's done a great job. But you also have those people that are repeat offenders. Those are people that you've given probation to. For some reason, they don't get it. They continue to come into the system. So then you might have to give them a split sentence of county time plus some prison time and put them on probation and hope you get their attention. But one of the things that you have to always do as a prosecutor when you're evaluating a case is you have to decide what is best not only for the offender but for the community, because you have to hold people accountable. And you have to hold people accountable. And I understand we're talking about violent crimes here, and I also understand we're talking about serious violent felonies. But that fella who gets up and goes to work, that mom who gets up and takes her child to school, and she sees the same person who is committing crimes in her neighborhood come out and being released, who is a repeat offender, they want something done. They want something done in their community, which means that we've got to separate those people for some time until we get their attention, until they finally grow up. And I know Senator Robertson knows this, how many people that you run into the street that say, you know what, you sent me away one day, but I'm thankful because it turned my life around. And you have to get their attention, and unfortunately, that's part of the system we have. And so you have to get their attention in order for the benefit of the community and for that person. And then you also have the third type of individual we deal with, the violent offender, the person who has to be separated from us for the sake of our children, for the sake of our community, and for the sake of the citizens in the entire state. So those are the type of people we're dealing with. But you can't do any of this unless you invest in the people that are in the court system. You've got to have prosecutors who have a career track. You have got to have public defenders who have a career track. Now, this year, I know that the Speaker of the House has said that we're going to get the prosecutors and public defenders back to where they should be, because when the Great Recession hit, we had lawyers, we had prosecutors and public defenders who have been stuck in the same scale, pay scale, for the past, now we're getting on 13 years. And these are seasoned prosecutors and public defenders who you have to have in the courtroom making those judgment calls. Because one thing about the criminal justice system, unlike anything else, almost everything you do is going to be based on a judgment call. We don't have a crystal ball. A judge cannot tell when he or she is listening to a case whether or not this person that they're going to grant bond or put on probation or even send to prison for some time, they can't tell whether or not that person will reoffend later on down the line. What they need is information from a seasoned prosecutor, a seasoned public defender who can help them evaluate these cases. One thing I always told grand juries when they would ask me, Mr. Scandalakis, what are you guys doing about crime? What are y'all doing about crime? And I would say, listen, we've had crime since Cain killed Abel, okay? I don't know that we'll ever do away with crime, but we will certainly do something to make your streets safer. Now, if you're looking for one magic bullet, I don't have a magic bullet about how we go about solving this issue. I can tell you this. If you want crime to come down, you invest in those patrol officers, those state patrol officers, those people working the streets, because they're the first wave, they're the first line of defense. They're the ones that will intercept that drug dealer who's dealing, now what we're seeing is fentanyl-based controlled substances. Fentanyl-laced, controlled substances. And we're seeing an increase in deaths because of that. The best way, you can't get to it after somebody's ingested that drug, but if someone is committing a traffic offense and a state trooper stops them and finds a bunch of counterfeit pills in the back of the car, you've stopped a crime. If a guy's thinking about robbing a convenience store and he sees an Atlanta PD officer patrol by, he's going to think twice about going in. So that's the first step. You invest in those patrol officers. And then the second step is you invest in seasoned prosecutors and seasoned public defenders. You've got to have them all. And if you don't have them all, the criminal justice system won't work. It doesn't function. We have been crying. We have been begging for resources for years. The DAs, the public defenders, the Solicitor Generals. We're overworked. We're losing good people. We're losing experienced people because they look at a job and they say, why am I working? You take a prosecutor who's been with the DA's office for 10 years. Right now, a 10-year prosecutor makes $70,000. $70,790, something like that. Less than $71,000. 10 years. A starting associate here in Atlanta makes $125,000. And that's probably a summer internship. You cannot, and we're not saying pay us the same that you would be in private practice, but we're saying pay the people to keep professionals in the courtroom, because you need that type of expertise to help you make those judgment decisions. Because as y'all well know, you can pass all the laws you want. You can pass all the statutes you want. But if you don't have people enforcing the laws, and if you don't have equally balanced public defenders and DAs, it's going to create a problem. And part of this problem is the backlog you're seeing now.
Pete, thank you for those comments and insight. Questions from the committee members? All right. Actually, I think Senator Jackson beat you to the punch.
Thank you, Mr. Scandalakis. Just a quick question. Can you tell us how many public defenders do we currently have? How many do we need? How short are we? What is this imbalance that you're talking about?
I do not know the answer to that. I wish I did, but I'll get that information for you and let you and get back to you. And as you may know this, the way the DA's office is funded is you get one state prosecutor. No matter how big your circuit is, you get one state prosecutor per Superior Court judge plus 2. So, for example, in my circuit, I had 7 Superior Court judges. I got one state paid one for every one of those judges plus 2 more. So I had 9 total. For a county, for a circuit of five counties, almost 400,000 people, 350,000 people, we had 9 prosecutors. 14 others were paid by the counties. So in almost all offices, you have the counties supplementing the DA's offices to get the resources necessary to prosecute these cases. And we generally, when I was there, we were usually 4th or 5th in the state in the number of cases that were submitted to the DA's office for review and then subject to go on, either dismissed, either filed accusation, pretrial diversion, or indictment. And our policy was we screened every case. So every case was brought into the DA's office. We had what is called vertical prosecution. An assistant DA put his or her hands on that case, reviewed it, and decided which track that case would go.
And just one follow-up question. So you talked about there being 3 different types of offenders: somebody who's done something stupid, a repeat offender, and a violent offender. Can you talk about the role that mental illness plays in this? I was at a recent meeting, and they said that the 2nd largest provider in the state of mental health care is our corrections department. So can you talk a bit about that?
Yeah, I would think the largest health care provider for mental health are our jails and our Department of Corrections. Second, that's the first time I've heard that. But that does play a huge role. And we were very fortunate that in LaGrange, Georgia, and now in the rest of our circuit, we have a mental health accountability court. And that helps divert people who would be coming into the system. But that is a huge problem. And again, I know the Speaker and the Lieutenant Governor have said they're going to devote some funding to address that situation, but that is a huge problem.
And we got 2 minutes left. Senator Robertson.
You answered my first question with the ADAs that were state funded. I was curious as to how those were divided up amongst the circuits. Are the public defenders divided up amongst circuits too based on population, or is there
Senator,
a formula?
I do not know the answer to that. I will have to get back with you and let you know.
Okay, and really quick, something that Senator Jackson alluded to, there's a great book out called Insane, and it will tell you that the top 3 mental health institutions in the United States are Rikers Island, Cook County Jail, Chicago, and Los Angeles County Jail, California. So you're spot on with that.
Thank you so
much for your time. We appreciate it. Okay, we're going to ask Tracy, if you want to come up, Mason, you can come up to the podium, and then we can have our 7 judges come sit up at the front here. We've got coming up Judge Brasher, Judge Kell, Taylor, Lakes, Casper, Duff, and subbing in for Judge Tomlinson, we have Judge Oliver. Tracy, why don't you go ahead and say a few words, and then we'll turn it over to the rest of our judges here. There should be 7 seats right there. I think we can get everybody in. So,
all right.
That's fine. Now you're fine. Tracy,
Okay.
please.
Thank you, Mr. Chairman, and good morning, members of the committee. My name is Tracy Mason, and I serve as Senior Assistant Director at the Judicial Council Administrative Office of the Courts. The Judicial Council is the statewide policymaking body for Georgia's judicial branch. It is chaired by the Chief Justice and includes judges from every class of court and the State Bar of Georgia. In attendance today are and available to answer questions, we have judges from Superior, State, Probate, Magistrate, and Municipal courts. I will be very brief to allow the majority of time for our judges. With the support of the General Assembly, the Council passed legislation in 2021 to provide additional tools for the courts during and after the statewide judicial emergency, including expanded options to hold court in alternative locations, judicial discretion to approve requests for bench trials, and expanded authority to charge by accusation instead of indictment. The latter two are time-limited, temporary tools to address the backlog. We are grateful for your support and partnership in assisting the courts to continue to function as safely as possible. As you know, Georgia courts operated under a statewide judicial emergency order from March 2020 through June 2021 in conjunction with the public health emergency declared by the governor. The first order was issued March 14th, 2020, and was extended every 30 days for the next 15 months as allowed by law, terminating June 30th, 2021 at 11:59 p.m. The orders required courts to remain open and continue to deliver essential services and encourage the use of technology to conduct remote proceedings when legal and practicable as an alternative to in-person proceedings to keep cases moving and the judicial system functioning. Because courts have the unique ability to compel members of the public to attend, including those who are not parties to a case, such as jurors, in-person proceedings required compliance and consistency with public health guidelines. The Judicial Council met frequently by Zoom during the emergency period to share information and guidance, discuss operations, and communicate during the pandemic. The Judicial COVID-19 Task Force, which includes representatives from each class of court and key stakeholders and partners, such as the State Bar, Prosecuting Attorneys Council, Georgia Public Defender Council, and others, was created to assist courts with conducting remote proceedings and restoring in-person proceedings, and it continues to meet. Thank you for allowing me this time to provide an overview of court operations over the past year and a half, and I will be happy to turn it over to Chief Judge Brasher, Judge Kell, and our other judges to talk with you.
Thank you, Tracy. We appreciate it. So I think what we're going to do is we're going to start and work our way down. While I would love to hear all of your all's background and history, we don't have time for that today. So if you could do just what your name is, and again, we're here to talk about specific things that we can do in order to improve the situation. And on behalf of myself and the committee, thank you for your service. Oftentimes we think about just our first responders who are out there every day, but this system works completely when we have everyone involved, and a very critical part is the work that you do in the courtroom. So let me say thank you, and we'll begin to work our way down.
Thank you, Senator Albert. My name is Wes Taylor, and I serve on the Fulton County State Court. I have since 2010. I'm going to keep my remarks brief. I will say that I was born and raised in Atlanta, so I have an interest in how things are going here as well as in my city and how we protect the public on the state court. In state court, of course, we handle misdemeanor criminal matters as well as civil matters of all types, but we focus on the misdemeanors. What I am going to do, if I may, is I will be available to answer questions or perhaps to provide remarks if needed, but I'm going to let Chief Brasher, since he is the chief of the Atlanta Judicial Circuit for the Superior Court, I'm going to let him take up most of the time.
Very good, thank you. Let's just keep going down the line here if we could.
I am Lori Duff. I am the president of the Council of Municipal Court Judges. I sit in the city of Monroe. I am proud to say that the municipal courts recognize the need right away to develop protocols and procedures for the operation of courts after the pandemic hit. We were the first class of court to develop a best practices memo, which was distributed on April 30th, 2020. This memorandum was used as the backbone of the protocol that was developed by the Judicial Council's COVID-19 task force. For the most part, the municipal courts did not cease doing the business of the courts. Most courts already had systems set up where tickets could be paid online, and those systems remained operational. Ticket windows in many courts were available for in-person payments. First appearance hearings and bond hearings continued to be held within the statutory time limits, and we as a class of court embraced the new technology wholeheartedly. Municipal court was well suited to being handled virtually. Almost immediately, we had arraignment and another calendar scheduled via a host of online platforms. In 2020, the last year for which we have data, municipal courts handled 756,706 cases, which resulted in an average 88% clearance rate of all cases filed. We are proud of the creative ways that we are able to keep the doors open, both virtually and in person, and although we don't have the numbers yet for 2021, the anecdotal evidence that is being reported is that municipal courts as a whole don't have a backlog. We, as municipal courts, have a unique opportunity to catch offenders at their first contact with the judicial system. Unfortunately, the system provides us with few tools in our toolbox. Because of the low level of our offenses, limited bed space in jails is reserved for more serious offenders. Georgia does not have sufficient resources to provide detox, rehab, mental health, financial literacy, or housing assistance programs that would help offenders stay out of the system in the future. And those are things that we could definitely use to help people from reoffending. I thank you for the opportunity to speak, and I'd be happy to answer any questions that anyone would have.
Thank you. We're going to hold the questions to the end, if that's okay. And if you could just share the microphones between you all, appreciate it.
Pretty loud.
Well, we've got people listening online, too.
Oh, perfect. Okay. My name is Quinn McGill Casper. I am here on behalf of the Magistrate Council. I'm the president this year of the Magistrate Council. I'm going to limit my remarks to be very brief. We are going to let Judge Brasher and Judge Kell have the first crack at it. But I just would like to point out that there's been a lot of talk about courts being closed during the pandemic. Magistrate court, as well as all the other levels of court, were open as much as they could be. We definitely have circuits where there's one magistrate judge, so if that judge got COVID, there's not a lot that we can do about that. But magistrate court was operating during the pandemic, was holding essential court, which was mostly criminal, and I'm sure there will be questions later about bonds, because as magistrates we do set bonds pretty early in the process. So I'm happy to answer questions that I can answer when the time comes. Thank you so much.
Thank you, Your Honor.
Good morning, Mr. Chairman. Thank you so much to the members of this committee. My name is Tane Kell. I'm a Superior Court judge in the Cobb Judicial Circuit. I'm a former chief judge in that circuit as well. I really appreciate the opportunity to be here before this committee this morning with my colleagues and friends, to be a part of a dialogue, to try to address issues that affect the state that I love and that you all love as well. I'm appreciative of the opportunity to appear before this committee also because, as you may know, the canons of ethics actually prohibit judges from speaking out on issues of public concern in most circumstances unless we have an opportunity such as this to come before the committee and address those kinds of things. So I really appreciate, and I know my colleagues do, the opportunity to be able to be here this morning and hopefully offer you some insights and some solutions about some of those things. I'm also going to defer to Judge Brasher first, and then I'll come back and offer my comments in the time that's allotted and remains if I can. Thank you all so much.
Thank you.
Good morning, Mr. Chairman. Thank you again for the opportunity to be here. Members of the committee, it's an honor to be before you to, as Judge Kell aptly said, engage in a dialogue with you all about what we together can do to make things better. We're here to talk to you about our accountability as elected Superior Court judges, as well as the operations of the court system, how it affects public safety, and obviously to offer some suggestions about things that we need that we think can make things better, but also to answer your questions that you have. I'm going to let my colleagues introduce themselves, and I'll come back and I've got some remarks if I could.
Very good. Your Honor.
Mr. Chairman and Senators, my name is Judge Rasheeda Oliver. I am the Chief Municipal Court Judge in the City of East Point, and I'm a part-time magistrate in Fulton County. So I have a unique perspective on seeing it from the city level and the county level. We do handle preliminary matters of misdemeanors and some felonies, warrants, and things of that nature. And so I'm going to yield to Judge Brasher, and I'll be able to answer any questions. But I would like to piggyback off of Judge Duff and say that at the municipal level, there are no resources. Things trickle up, but they don't normally trickle down for us to support the rest of the judiciary from the perspective of we see those that have mental illnesses fairly early. We see people who have domestic issues that start with disorderly conducts, and then they just kind of, escalate. But there's nothing there at the municipal level to kind of put a hold on things as we should. And so funding in that area would definitely be supportive of what the state and superior courts would be seeing as well.
Thank you. If you grab one of the microphones there. Thank you.
I'm a Judge Casper. I'm fairly loud. Thank you, Chairman, and a special shout out to my Senator, Randy Robertson, here for allowing us to come before you. I echo the comments of my colleagues here. We're certainly appreciative of the opportunity, and like my other colleagues, we will yield our time to the judges who are more familiar with the local area here. But from the probate court perspective, I guess I should introduce myself. Thomas Lakes, probate court judge in Harris County. I'm also the president of the Council of Probate Court Judges this year. We get mainly the Title 40 offenses that were mentioned earlier. So like our magistrate and municipal friends, we see a lot of folks on the front end of the issues. I really don't have too much more to add so far as what's been said. We see the mental illness issues on the front end. We have the lack of the same resources to address those sort of things. I think if that were a focus of where some resources could be put in to remove that from being the majority of the treatment that comes through the criminal justice system and put that into the hands of more of the community resources that are available there, that would be an important step. But I appreciate your time, and will again be available for questions as it relates to our class of court, but we'll defer to my colleagues here in the area. Thank you.
Great. We'll turn to Chief Judge Brasher, please.
Thank you again. Again, I'm Chris Brasher. I'm the Chief Judge of the Superior Court of Fulton County. I've been a judge in Fulton County for 15 years on the Superior Court, and prior to that, I was a prosecutor for about 5 years, and then I worked at the State Attorney General's office representing all of the state-level public safety agencies for about 12 years after that. As a trial court judge in Fulton County, Superior Court judge, I have adjudicated about 15,000 cases in my 15 years, tried about 300 jury trials, including 100 murder trials and 2 death penalty cases since I've been on the bench. I want to tell you that the good news is your courts are open and have been open throughout the entirety of the pandemic. Not a single day did the Fulton County Courthouse close. We've been open every day, and we've been doing business. We transitioned very quickly to doing things virtually. In the week after the statewide judicial emergency order came into effect, we acquired 50 Zoom licenses. We now have about 250. We do most of our hearings from the jail remotely, so we're not bringing 200 inmates over from the jail every day. These are things that we need to keep doing after the pandemic. I've told folks if we're not doing those things 3 years from now, shame on us. And that includes picking juries in civil cases via Zoom. We've been doing that since April. Since the courts expanded their in-person operations in April, we've tried about 70 jury trials in Fulton County. We've had a lot of success with that. That represents about 50% of our pre-COVID capacity. We hope that by the end of the year we'll be back to pre-COVID capacity as far as jury trials are concerned. We've also adjudicated about 7,000 cases in that same period since June of this year, since May of this year, so the last 6 months. So the good news is the courts are open, have been opened during the entirety. I want to say a special thanks to Chief Bryant, who I count as a friend and a partner to our courts. First of all, we see several score of his officers in our courts every week. I sign search warrants and other warrants for his officers. I have them as witnesses in hearings, and I appreciate the professionalism and dedication that his officers have shown, even during the difficult times during COVID. We still were there to help them, and they were clearly doing the good work of law enforcement officers. We also owe a thanks to him and to the Atlanta Police Foundation for the partnership that we've been able to forge with them, because it's through the efforts over the last several years that we've been able to identify repeat offenders. And in fact, now repeat offenders are specifically identified in our court system. They carry a special designation. We track their cases individually, and it's because of the assistance of the Atlanta Police Foundation and the Atlanta Police Department that we've been able to do that. And we've had a lot of success dealing with them both at the pretrial level and at the sentencing level. And so I want to ask you, I know the question has been, what do we need? And I've got several things that I want to highlight on that. The first is we need better data. As you may know, there are thousands of unentered dispositions around the state of Georgia. Estimates are 80 to 100,000 unentered dispositions in criminal cases. What that means is that we get GCICs, so people call it a rap sheet, whatever you want to call it. We get GCIC printouts, and they're only as good as the data that has been entered into them, which means that when we look at an offender's criminal history, and there isn't one, that may or may not be true. Or it may show an arrest without any disposition, or it may show an incorrect entry. It may show a first offender that appears to have expired, but we don't have any information on it. So we need better information so that we can make better decisions at the time when bond is considered, as well as at the time when sentences are imposed. We need better supervision of pretrial released detainees. We've got 3,100 people in our jail, which is 600 over capacity right now. The last time we were at that rate of overcapacity, we had a federal monitor imposed on us by the federal court. It lasted for 3 years and cost tens of thousands of dollars to the people of Fulton County. So we have a full jail. The county commission is considering whether to build a new jail at the rate of $400 million. So those are the things that we balance when we make those decisions. When the pandemic began in March of 2020, about 15% of our jail population, which was then 2,500, was unindicted. Now 55% of our jail population is unindicted. So cases are working their way through the system, but it's happening slowly. During that same time period, about 12,000 people were arrested for felonies. And you can see if there's only 3,100 in the jail, that means there's another 9,000 people that are released on bond. We need better supervision around the state. In Fulton County, we actually have a very effective pretrial supervision program. I've left some documents on the table that I'll ask you all to pass around. It's pretrial supervision summary reports. So what that shows is that in any given year, we are supervising somewhere between 12 and 17,000 people on pretrial release. The failure rate for pretrial release is 5%. So you might think, well, that's 5% of the people who don't show up for court. That's not true. The failure to appear rate is less than 2%. When in pretrial release, the failure to appear percentage is less than 2%. The rest of the 5% is made up of people who fail in their supervision of pretrial. So they don't report like they're supposed to. They have a dirty drug screen, whatever it is. We issue a warrant and have them arrested again. So again, our failure rate may be 5%, but our failure to appear rate is 2%. That's for felonies. Misdemeanors, they also supervise. So I'm only talking about felony cases. When we talk about bond, the first thing I want to start out with is that it is a presumption under the law that bond is permitted in every case. Only if the court examines 4 factors that are set out in a Georgia Supreme Court case and also in the statute can we deny bond to someone. If they're a danger to the community, if they're a danger to reoffend, if they're a danger to commit additional felonies. We had to look at those things and those factors and make those determinations. Now we're back to the information issue. If we have good information and we have folks who can give us that information, as Mr. Skandalakis said, both on the prosecution side and the defense side, we can make good decisions. In Fulton County, only elected Superior Court judges may grant bonds in the 7 deadly sins. So the offenses that you saw on the screen, those are referred to by lawyers as the 7 deadly sins, serious violent felony cases. Only elected Superior Court judges can give those. We have specifically instructed by order that our magistrates may not do that. In addition to that, magistrates when considering a bond, or any judge when considering a bond, must understand that there's a rebuttable presumption that anybody who's been convicted of a serious violent felony before, that there is no set of circumstances that could reasonably cause them to be released, whether it's a monetary bond or a non-monetary bond. It's only those offenses below that the magistrates and the Superior Court judges will consider. Now, why do we use pretrial release in Fulton County? Why do we have it as a part of our court? We've got 25 employees whose full-time job is to deal with pretrial supervision and pretrial release. It's because if we didn't have it, we would have 3 jails full of people. We could not set monetary bonds low enough to actually get people out on bond. And Senator C., your question was one that is insightful, and that is in our pretrial program, we have drug treatment, mental health treatment, referral to other community services. So that's really the key to helping people get into a situation where they're not reoffending. People do reoffend. They reoffend when you release them on bond, they reoffend when you put them on probation, and they reoffend when they serve time in prison and get out. But the percentages are very low on pretrial release. The other thing I want to talk to you about is, in addition to better data and better supervision, is whatever it is that we do, whatever it is that you all do, I know that you want to do it based on evidence, based on evidence-based programs. And so what I'm here to talk to you about is the serious violent felony issue and how we can address that, in addition to the repeat offender issues. I've already said that we've specially tracked repeat offenders in our county. We are accountable publicly on those cases. Everybody knows what judge has how many of those cases and how those cases are resolved. The Atlanta Police Foundation also, in addition to our own county government, publishes that data. Likewise with serious violent felony offenses. Everybody knows how many of those we got, and they know what we do with them. So I want to reiterate to you that we're open, we're doing the work that we're supposed to be doing. We actually have a plan courtesy of the American Rescue Act funds that were given to Fulton County by the federal government. We have a plan in place that will expand our capacity over the next 3 years by 25%. So we're going to stand up additional courtrooms. We have already stood up additional courtrooms. We have assistant district attorneys and assistant public defenders who are being hired with those funds. We have court personnel. We have senior judges that are going to assist to try and work our way through the backlog. As I said, we had 12,000 people arrested during that time. We know what the what the denominator is. We're working on the numerator. We're doing that through all the things that Mr. Skandalakis talked about, pretrial diversion, other things like that, but also increasing the capacity of the court system so that we can move more cases through. You all have heard me talk at you long enough. I'm going to turn it over to Judge Kell. He's going to give you some perspectives on how things are going in Cobb County as well.
Thank you, Your Honor.
Thank you.
Thank you, Chris. I appreciate the opportunity again to talk about all of this. I'm going to read some remarks that I've prepared for you. If you know how ADD I am, you will appreciate the fact that I have prepared remarks in advance and will read them to you. I also have a copy of them, Mr. Chairman, if you would like a copy of those when I finish. I thought it would be good and helpful for the committee to outline what I call the history of the current crisis, how we get to where we are today, and understand I can't address law enforcement solutions to issues or what I see outside the judicial system. I'm here to talk to you about how I think we are where we are today, and also to offer what I believe are 5 points from my perspective as Tane Kell in the Cobb County Judicial Circuit that would be helpful. I promise Chris and I didn't copy each other's homework on this, but some of them may sound familiar to you. When the Chief Justice issued his first judicial emergency order on March the 13th, 2020, an ad hoc committee consisting of myself and 2 other judges in my circuit had already been discussing some preliminary plans to continue court in the face of the mounting public health crisis. We searched online for pandemic court plans, and there were none of substance. We called our colleagues in other circuits and in other states and began an online dialogue with our partners like the district attorney, the circuit defender, the local bar association, the sheriff, sheriff, the clerk, and other courts to think through the myriad potential scenarios. With no guidance and starting with a blank sheet of paper, within days we had an initial plan for socially distanced court and began rewriting the centuries-old book on how to conduct a trial court. We guessed at what the CDC's initial guidelines meant and how they would apply to the courts. Then we did the best we could to draft short-term and long-term plans in the event that the pandemic continued. Thank goodness we thought to do that. Within 3 days of the Chief Justice's first order, emergency hearings were resuming in a limited socially distanced environment, and within days we resumed our accountability courts programs so that we would not risk losing a vulnerable population of citizens to addictions and to mental health illnesses. During what amounted to a statewide lockdown in those initial days and weeks, our staff made and fielded 1 million calls and emails on whether and how court would be conducted. Schedules were shuffled and reshuffled. Staff worked from home and transferred office phones to their personal cell phones and forwarded their emails to personal laptops just to get the job done. Our one IT person, and God bless him, we're glad we had him, in Superior Court worked every night and every weekend to keep our systems up and running and to install the countless new programs and pieces of hardware that we required. We figured out how to conduct Zoom meetings or WebEx calls in our living rooms and kitchens and reached out to each other and everyone else we could think of for technical assistance. My teenager was my in-house IT expert for months, and I mean that sincerely. Most judges purchased Zoom subscriptions out of their own pockets just to expedite their ability to conduct court hearings. We educated our staff in the local bar on new procedures and spent endless hours writing and rewriting guidelines and directories for how to conduct court via video. We shared our ideas with other circuits and solicited their input for fresh thoughts and perspectives. We sat through webinars and emergency meetings to find new solutions for unique problems no one had ever contemplated. And we adapted these new procedures to conform with existing rules and procedures, some of which were written before courtrooms had electricity. Early on, we began discussions of how to conduct jury trials if it came to that in a COVID-stricken world, and we used media such as podcasts and video seminars to share ideas on how to get courts and hearings up and running. While still trying our best to attend to emergency hearings in the criminal context, we began holding civil hearings and bench trials by video. We had to educate new sets of attorneys and new self-represented litigants on how to manage a hearing remotely. The phrase, "you're on mute," became a part of every transcript of every virtual hearing. We applied for federal funds to get equipment, PPE, air filters, and the like, and we retrofitted courtrooms and makeshift spaces to use as courtrooms. We sought the readily available assistance of the Chief Justice and local health officials and lawyers and IT experts and anyone else we could find to make sure that we were exploring all of the potential resources to move cases. By June of 2020, 3 months into the judicial, less than 3 months into the judicial emergency, we were running at the fullest capacity that the health guidelines would permit, and cases continued to move. What that means in my circuit is we were in the office 5 days a week, holding court the entire time during those periods of time to the fullest extent that the health and safety guidelines would allow. In Cobb County alone, over the first 10 months of the pandemic, we held 7,508 civil hearings and closed 6,054 civil cases. Closed them, finished them. In the criminal context, we held 22,733 criminal hearings, many of those on an emergency basis, and we concluded 3,602 criminal cases in the first 10 months. We also reduced the jail population by almost 50% in the initial months of the crisis in order to reduce the risk of COVID spread at the jail and allow us to be able to continue to hold hearings in the fashion that we needed to do. In September of this year, moving forward, we have conducted 7 jury trials in the month of September. 5 of those reached a verdict and 2 pled out. This necessitated calling in 321 jurors for service, with 72 actually serving on juries. Now understand, that's far below our pre-COVID capacity, but it's all we can do with the current COVID guidelines that we're working under. While we were doing all these things, people around us were contracting COVID, and we interrupted our new normal to quarantine and reschedule matters. My own son contracted COVID, and I conducted hearings from a makeshift courtroom while quarantining in my master bedroom, complete with an American flag behind me, while live streaming to the courthouse for open courtroom purposes. Like you, our friends in the legislature, we had no option to shut down and wait it out. The judicial branch, like the legislative branch, had to soldier on and had to find a way to carry on business during the crisis. So where are we now? We are still certainly in crisis, but we have a game plan and we are moving forward, and that goes for every judicial circuit in the state of Georgia and every court at every level. Most courts are conducting both criminal and civil hearings via a hybrid system of video and in-person hearings. Most jurisdictions are also conducting jury trials at a measured pace, balancing the demands of the burgeoning backlog with the stringent requirements of public health and safety. In Cobb, we developed a detailed jury plan during the time that such trials were prohibited by the order of the Chief Justice. And as soon as that plan was authorized, we began executing it immediately. Since that time, we have steadily conducted trials in criminal cases, resulting in many cases being tried since April of this year, which was the first opportunity we had to begin them again. But until the pandemic eases and the CDC guidelines are reduced or lifted, we have limited ability to return to normal, much less to take steps to reduce the backlog. For example, while the 6-foot social distancing restriction continues, though we have 10 Superior Court judges and 11 courtrooms in Superior Court, we can only conduct 2 simultaneous jury trials in our courthouse due to capacity problems with those courtrooms and with our only jury assembly space. Other jurisdictions have it even worse, with few judges, limited resources, and even more limited space. Jury trials will continue in those circumstances at a slower pace than pre-pandemic. So, I told you I would come here with some solutions and some answers, and that's where I'm headed now. First of all, I want to tell you 2 things that I think the solutions are not, and I hope you'll understand this. I don't think that a solution for where we are right now is a reduction of the opportunity for bond. As Judge Brasher said a moment ago, bond is a constitutional mandate. The Constitution of the United States and the state of Georgia require bonds in all misdemeanor cases. It's not within our discretion. In addition, what most people do not understand is that bond is also required in felony cases unless one of 4 exceptions exist. And Judge Brasher talked about those a minute ago, but we have to actually find, in order to be able to deny bond, that the defendant poses no risk of fleeing from the jurisdiction or failing to appear, poses no significant threat or danger to any person, to the community, or any property, poses no significant risk of committing any felony pending trial, or poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. In order to make one of those findings, we have to have evidence of those things, and if we do not have evidence of those, we cannot deny bond. I also do not believe that the answer to the current crisis or to the current situations is the return of mandatory minimum sentencing. The era of mandatory minimum sentencing had its heyday in the 90s and lasted in Georgia until the adoption of the Criminal Justice Reform Act of 2011. I believe that it was a failed experiment, and I believe that the data upon which the Reform Act was based bears this out. So, let's get to what I think the solutions are, and I'm going to give my disclaimer. These are Tane Kell's recommendations and no one else's, but that's why you asked me here today. I believe that there are at least 5 possible judicial solutions to assist in reducing serious violent crime. Number 1, accurate and expedited criminal history data for judges. Number 2, pretrial supervision for those on bond, and I'll explain what I mean by that in a moment. Number 3, following the data with regard to the issuance of bond. Number 4, increased funding for senior judge assistants, and I'll explain what I mean by that. And number 5, simplification of video hearings for judges. And there's one other one I may talk about, which is also training if I don't run out of time. First of all, criminal history data. Most decisions regarding the issuance of bond, as my colleague has said, are made by the judge based on criminal history data. This related direct this is related directly to the bond consideration factors I discussed a moment ago. Most judges make this prediction of future behavior based on past criminal history. We receive our criminal histories from the GBI's Georgia Crime Information Center, or GCIC database. As Chris said, that information is critical to these decisions, and it needs to be as up-to-date and accurate as possible. Understand, this data is entered by the local jurisdiction and then verified and added to the database by GCIC. And so in order to get that data to be accurate and be immediately entered, increased funding to assure sufficient manpower both locally and at the GCIC level is a critical function vital to the accuracy of this data. If the local jurisdiction doesn't have someone to put it into the system, then it doesn't end up in the system, and there's nothing GCIC or the GBI can do. Pretrial supervision, and I promise I'll finish in just a moment, Mr. Chairman. Pretrial supervision. So in my county, unlike in most jurisdictions, I have the power to put someone on what we call pretrial supervision as a condition of them getting bond. I have this ability only because my county has allocated sufficient dollars for a private company, a private service, to supervise arrestees while they're out on bond. We treat those who are out on bond much like people who are on probation, often subjecting them to reporting requirements, drug testing, and other restrictions supervised by that by that private company. But understand, resources are unavailable in almost every circuit for this. Only in the metro Atlanta area, I think, do you have pretrial services available. So getting to Senator C's reference a few moments ago, I have the ability to make certain that people are participating in mental health treatment or things that they're supposed to be doing while they're out on pretrial supervision. If I put them out on bond, I can make it a condition of bond, but there's no one there to supervise it to make certain that it's happening. The third suggestion that I have is following the data based regarding the issuance of bond, and hopefully you'll get more data on that. I don't have it. I wish that I did. Criminal defendants, though, I will offer to you, rarely engage in a logical matrix of decision making prior to offending or reoffending. I think certainly Senator Robertson can attest to that. They don't say, hey, I already have a $10,000 bond on my drug possession case, so I don't think I'll do this drive-by shooting because it might not be in my best monetary interest on the other case. So I don't believe that there is sufficient data out there to indicate that things such as increasing the amount of bonds for certain conditions as a deterrent for future criminal behavior. I don't have the data on that, but it may be available. I'm sorry?
I'm sorry, I'm going to let you finish. I was just saying most of the parents are paying for it.
Yeah, that's exactly right. Or you know, Aunt Sophia is putting her property up for my bond, and I don't really like Aunt Sophia, so I don't really care what happens to her house. But at any rate, I would urge you to base any decisions like that on data. Video hearings legislation. Last year and the year before, there were proposals. Last year, it was House Bill 371 to allow courts more flexibility in conducting especially criminal hearings via video. It saves time, it saves a ton of money, and it also puts those who are required to transport those inmates back and forth at less risk, moving them back and forth within the prison or the jail, not moving them back and forth from the jail to the courthouse and the courthouse to the jail. Finally, senior judge funding. I believe that one of the greatest resources that we currently possess to help us alleviate the backlog of both criminal and civil cases is our senior retired judges. While it is not the only proposal, I believe that significant increased funding for the use of senior judges can and will assist jurisdictions in attacking this backlog. In my jurisdiction, for example, senior judges could be employed on an ongoing basis to cover civil hearings. To alleviate the courtroom space considerations, these hearings can actually be held virtually when courtroom space is at a premium being used for criminal matters. This strategy could free up trial judges such as myself to try more jury trials and address the backlog. In fact, though we cannot conduct criminal jury trials virtually due to the Confrontation Clause of the United States Constitution, civil jury trials can and are being tried virtually. Senior judges already trained to handle these cases could easily try a number of civil matters, freeing up the sitting judges to try criminal cases. But as we all know, this takes money, and we don't have that right now. So I'll leave you with this. Mr. Chairman. My father was a football coach, and I heard him say many times that he did not pat anyone on the back for doing his job. What the judiciary did and what you did as the legislature during the time of this crisis over the past 2 years, that was our job. We kept the courts and the General Assembly open. We took our oaths seriously, and we upheld the Constitution and laws of the state of Georgia and the Constitution of the United States. And that is what we will continue to do through the duration of this pandemic and in the face of any other challenges that may come. Thank you all very much for that, your time.
Thank you, Your Honor. I'm going to start with some questions, and I know the committee has some as well. First question, and I'll direct it at the two speakers, but everybody's welcome to talk. But again, please know that we have about 22 minutes left. Sure. The first one's going to be about dead dockets, and I'd be curious to know where that is today in your respective circuits and what we think the issue is both locally and statewide.
So a dead docket is a way to dismiss a case, if you will. Dead dockets generally occur in two circumstances. One, based on some kind of pretrial diversion or other set of conditions that's established by a prosecutor and or a judge, and then a charge may be dead docketed if those things are fulfilled. And it's also probably more frequently used as part of plea negotiations between the prosecutor and a defense attorney. So a judge cannot reduce charges. A judge cannot dismiss charges except through the adjudication of a case, unless it is asked for by the prosecutor. And so in our court, for instance, there may be a 5-count indictment, and pursuant to plea negotiations, 2 of those counts may be placed on the dead docket in exchange for a plea of guilty to the other 3. And there will be a negotiated sentence that's offered. And that's how those cases get dead docketed. The other, as I mentioned, is if it's in response to some kind of pretrial diversion, et cetera.
Very good, thank you. Next question is, we have a backlog still that we're trying to catch up for. So prior to COVID, we'll call it January, February of 2020, do you know how many cases we had that were felony criminal cases that were pending versus what we are now as far as a backlog is concerned?
So the answer is complicated a little bit by one of the facts that I gave you earlier, which is the number of unindicted cases. What I know is, again, what the denominator is of people that were arrested. Prior to COVID, we had a backlog, the operating backlog, if you will, of probably 3,000 to 4,000 cases. Now we have an operating backlog, if you include the unindicted cases, of somewhere around 13,000 or 14,000. During the pandemic, we actually, as the saying goes, made hay while the sun shone and reduced the number of previously indicted pending cases. That's where we've made a lot of headway in our court, because we weren't getting newly indicted cases or a trickle of newly indicted cases, and that's the way it's been basically for the last year and a half. And so our numbers have gone down significantly. The per judge numbers have reduced by about 50% during that time. And so, our admonition to our colleagues, both in our court and elsewhere, has been clear the decks, because new opportunities are coming. I expect, based on where we see indictments going, that by the end of the first quarter of next year is when we'll see the numbers really picking up. In our jurisdiction, and I don't intend to speak for the district attorney, I know that her focus has been on murder cases, getting murder cases indicted because of the removal of the stopping of the 90-day indict or release limitation. I extended that by 90 days in our local jurisdiction pursuant to local emergency orders, but we've run out of that capacity. So they're indicting murder cases, then they'll transition to other serious violent felony cases. So I expect to see those numbers go up.
And if I could just 2 quick things about that. We did the same as Fulton County did with the things that were already indicted. We spent the time during the pandemic, once we were able to get things up and running, to try to clear as many of those cases as we could. As most of you know, 99% of our cases aren't cleared by trial, criminal cases. They're cleared by pleas or negotiated pleas or something that's worked out between the prosecutors and the defense attorneys that then come to us for disposition. What I will say is this, though, and Chris may back me up on this, there are cases that have to be tried. That 1% of cases that will never be resolved by a plea agreement have to be tried. The gloom and doom I'm going to paint for you here today is I'm not even close to trying the cases I already had specially set in 2020. And by the end of this year, I won't have even tried the 6 or 7 cases that I would have tried in 2020. That means in 2022, I will still be trying 2020 cases, and in 2023, I probably will start trying some of the cases that would have tried in 2021. So when we talk about the backlog in the context of criminal trials, it's a substantial backlog for those cases. And remember, that means that in many of those cases, people are sitting in jail who haven't been convicted of a crime and are just waiting for a trial.
Thank you.
Thank you.
Quick comment, the pretrial supervision certainly is doing exactly what it's intended to do, and I appreciate that.
Yes, sir.
I want to talk about the jail for a minute. We had Sheriff Lavat here, who gave a great presentation at the last meeting. My understanding is because of the overcrowding in that jail, we have folks that we'd normally not be letting back out that we're letting back out. Is that a fair statement?
I hesitate to agree with that, and here's why. First of all, we did, as Cobb County did early in the pandemic, we had gotten our jail population to about 80% of capacity, which is as low as it's been in my tenure on the bench. So we were at 2,200 or so. We're now almost 1,000 higher than that, and that's accumulated over the last 12 months. So in August of last year, we'd gotten the population down. Now it's at 3,100. It's been hovering right at 3,100. So I'm going to give you a very frank answer. Are there people who were charged with crimes during COVID who got a bond who might not have gotten a bond otherwise? Perhaps so. But I will tell you that there's a reason why the number of people in the jail has gone up so significantly and the percentage of unindicted has gone up, and that's because people that are charged with serious violent felonies are not being released on bond. People who are repeat offenders are not being released on bond, as we've talked about and as we've worked with APD and the Police Foundation.
Which is good, but we still have the problem with overcrowding. And I know you mentioned the 400 million number, and in government terms, it's always going to be higher than that, right?
Absolutely.
And this is a message for my friends in the city of Atlanta that are here. Once and for all, I'm asking you right now to turn over the Atlanta City Jail to Fulton County and get this done. That building is sitting there, it is capable, and it is able, and we can do better. Fulton County and Atlanta have to work together on this issue once and for all. That will solve an immediate problem. Next question for you is going to be about the bonds. We've got some pretty defining evidence of folks that are not following the law that actually passed this committee and was authored by Senator Robertson to my right. I'm going to ask you to comment on that, but I'm also going to ask for your help. We have a list of all the folks that are not following that law today, and I'm going to ask you to please self-police yourself. We're going to give it a month, and after that month, we're going to start making that stuff public. And we don't want to do that because we want to all work together, but just like all the rest of us, we all got to follow the law. And this is not meant to be punishment to anybody, but I mean, these numbers are pretty straightforward, and the law is the law that we have to follow. So I'd like you to comment on that, please, as well as perhaps a way that the judge organizations can self-police themselves.
Well, the first thing I'll start with is that I know there's not a single judge on any of the courts that are represented here that intends to not follow the law. I'll tell you, and I understand that has happened. I don't quibble at all. I know that it appears pretty clear that the numbers have gone down significantly of inappropriate judicial, non-monetary judicial release, but any amount that's occurring is inappropriate. And so I'll pledge to you that communication will go out to all classes of courts in our circuit, and I'm sure that the other judges will do the same thing, that henceforth we expect that there will be no violation of that limitation. So one thing I'll say is, the presentation by the representative of the bonding industry was very enlightening. It's helpful to understand that they understand, as we do and as you all did, that the amount of actual money that's put down for a bond can be very low. I'll tell you that I have been in conversation with some community groups that would be willing to put forward money in circumstances like that to help. And that's fine, so long as we're complying with the law. I think that's appropriate. So I've made my pledge to you, and I intend to honor it.
Thank you, Your Honor.
Mr. Chairman.
Go ahead. Yeah.
I'm sorry.
No, you go ahead.
So I just wanted to jump in
Can you
because
pull the microphone a little closer?
Certainly.
Thank you.
Because I just have a unique perspective on that. And so from the bond perspective, there are some cases that are unrestricted, that are restricted, and then there's others on that same case that may not be. And so the use of pretrial services on part of that as a split bond has been very effective. So they are posting bonds on part of it and actually being supervised on the other part. And so because of the guidelines that Judge Brasher has put in place, particularly for those that are designated in Fulton County, as well as the list of restricted violations that we received, that as soon as I'm in court, I have both of those guidances up in front of me so that I know, and I'm instructing other people if it's restricted. And I know the other judges that sit on the bench that I sit on are reviewing that. I think it's important to have that in front of them, and maybe they don't have it in a concrete manner and hadn't read all, maybe 400 pages of what's there for them to fill through. But we have gone through and identified very succinctly those cases that are in fact restricted, along with the delegation order that we received from the chief judge, Judge Brasher, in doing that. And so I think it's important to recognize that the bonds are not handed out as candy. And there is a perspective that has to be done when you have murderers on a calendar and you have people who may have shoplifted or done some other things. You do have to make a judgment call as to who's going to stay and who's going to go based on the statute and the laws that we have to follow. So I don't want it to be perceived that anyone is just willy-nilly throwing out and giving people bonds. We're taking the information that we receive. Some of that information is time restricted on the GCIC record, so we don't have any information beyond the person that's there. We may receive that there is a juvenile record that we can't see that may tell us what a 17-year-old has been doing for the past 5 years, that we may not have that information. So it's a lot of information that we do need in making these decisions, but I don't want anyone to believe that these things are just happening in a vacuum, because they're not.
Thank you, Your Honor.
One other quick comment. In hearing criticism such as this about one of the issues they raised was non-elected judges assisting judges granting some of these bonds. As a more long-range solution to those criticisms, which we had heard before, not just in the current crisis, last year the Council of Superior Court Judges passed a rule indicating that any judge who is assisting as a Superior Court judge is now mandated to have mandatory CLE, mandatory training in Superior Court rules, procedures, and laws that would apply to them. So that's a more long-range solution, but I just want you to understand we hear those criticisms and we're trying to do something to address those.
Thank you. Appreciate
Yes, sir.
it. Question from Senator C.
First and foremost, I did not catch, Your Honor, from where are you and your name? I got a list here, but I wasn't able to check it off because I'm not sure, huh?
I'm sorry, my name is Judge Rasheeda Oliver. I'm Chief Municipal Court in the city of East Point.
Okay, so you are not on there.
No, she came in the sub for Judge Tomlinson.
Tomlinson.
Okay, and you're
And a
from
part-time Fulton County magistrate.
Fulton County. Okay.
Thank you.
And two
Yep.
more, because I checked off my list and I don't see Lori. Is Lori B?
Yeah, here.
That's you, okay. And Billy Tomlinson?
He's not.
He's the one that,
No.
That's the one. Okay, now I'm straight.
We
Go
got them all.
ahead.
All right. Okay, I've got a question from Senator Jackson.
Thank you, judges, for taking the time to be with us. We really appreciate it. Judge Kell, you mentioned some non-solutions, and I'm
Yes,
wondering
ma'am.
if you could say more. One of the things you said was increasing or returning to mandatory sentences
Yes,
you
ma'am.
believe to be a failed experiment.
I do.
Can you expound on that some more? Because we've
Sure.
heard an awful lot of talk in these committee meetings about returning to mandatory sentences. So we'd love to hear your perspective.
Well, historically, if you look back, we've sort of waxed and waned with respect to the philosophies of whether, we just take away the discretion of judges to sentence people and make sure that for certain criminal offenses there are mandatory minimum sentencing. There was a great amount of research done on mandatory minimum sentencings and whether that was effective, done between really the 80s, the 1980s, and then the passage of the Criminal Justice Reform Act in 2011. Pew Research Foundation did a ton of research on this. A number of other organizations that really didn't have a dog in the fight did the same thing. What it showed, at least from my perspective and to my satisfaction, is that there was no real effect of mandatory minimum sentencing except one. It filled up our prison system with people who very likely or perhaps in some situations didn't need to be there and didn't have to be there. I heard our former district attorney say on a number of occasions two things. Number one, we can't incarcerate our way out of any crisis. And number two, we ought to put in prison the people that we're afraid of, not just the people we're mad at. And we did a lot of, during the 90s and 2000s, putting in jail people we were mad at. We said, if you drive drunk again, we're putting you in jail. You know, it's okay. We decided and we realized that there were other programs such as DUI courts and intervention type programs that were more effective, more cost effective, and made a lot more sense. So I just beg this committee and anybody else who hears someone say, well, we should just return to mandatory minimum sentencing, look at the data that was out there from when we did those programs and the level of cost it is and the effectiveness of that.
Your Honor, I want to comment on that just for
Please,
a moment,
yes.
if I could. And I appreciate that perspective. And there are certain things, clearly, that shouldn't have a mandatory minimum. However, I'm going to use your DUI one as an example. And I had a very close friend to lose his brother and sister-in-law for that person that had their 5th DUI, who was not behind bars, who was between judge to judge to judge, and constantly got passed through the system, right? And I know that in most cases, our judges, just like all the other folks in General Assembly or first responders, are good people. But we do have some that don't want to be judges. They want to be either legislators or they want to be social workers.
Agreed.
Right? And that's the reason why those laws were put in place. And for those that are committing the crimes that are taking people's lives or their security away from them, that is the concern of the legislature for some of us, not all, right? We have different opinions. Senator Jackson and I might disagree on this issue. However, that is part of our concern when those repeat offenders who have done that, whether it seems violent or not, they took 2 people's lives. That's a mom, an aunt, a daughter, a husband, a father, and that just doesn't work for me.
Sure.
On that one,
Sure.
That would be a municipal court issue. The most you can lock someone up in municipal court is a year, and eventually they're going to get out. You know, a year.
Exactly.
A year. Okay. So, you know, eventually they're going to get out. And without treatment for the addiction issue, someone who has 5 DUIs has driven drunk at least 20 times. You know, they've only been caught 5 times. And they have a serious alcohol problem. And unless you deal with that serious alcohol problem, they're going to get out at some point, and at some point they're going to do this again. Clearly, incarcerating them is not fixing the problem because you've done it 4 times already and it hasn't done anything. And that's why when I was talking about resources, that's why DUI courts, like Judge Kell was talking about, are so effective. And if you look at the data with DUI courts, you can lock a DUI offender up for a year and they get out. They're more likely to reoffend than someone who's been through a DUI court. Just the raw data will show you that, because it doesn't just punish them. There's a retributive factor, but there's also a treatment factor. It costs money on the front end, it saves money in the long run, because it treats the problem and fixes it. It fixes the addiction issue. It's a practical solution. I was a prosecutor for the first 10 years of my career. I understand what the desire to, I understand the thought, well, at least if they're in jail, they're not killing anyone. I understand that. But they're going to get out, and then what? Then you have not only someone who still has that underlying problem, but someone who can't get a job, someone who's been, someone whose situation is much worse than they were when they went in, which, what do? Their coping mechanism is drinking. So, how are you going to fix that? You got to fix the underlying problem, and that takes resources, which Georgia doesn't have. I can order from my seat on the bench all day long that people find. I can't order constitutionally. I can't order someone to go to AA if they don't want to, because AA has a spiritual base to it, and it's a First Amendment violation. I can order them to go to rehab, but I can't order that there be a bed available. I can't order that somebody who makes $8.25 an hour suddenly have $20,000 to pay for rehab. That just, those things just, they don't exist. There are no public resources for these things. And in oddly enough, in municipal courts, specialty courts are not allowed legally. We can't have DUI courts in the courts that handle the most DUIs. Why is that? I don't know. Y'all are the legislators. You tell me.
This is a great recommendation, Your Honor.
Yeah.
That's something that we can do.
So that you know, I would love to be able to have a DUI court in municipal court. I would love to be able to have a mental health court, because research says that those are the things that are going to have the best results, that are going to keep people from killing my kids and my friends and my neighbors and my relatives, which is the end result we all want. And my guess is, I don't know, that fifth DUI offender in your situation had never been to DUI court.
Nor had he spent any time in jail.
Mm-hmm.
And that shouldn't be. And my guess is that also relates to the GCIC problem, because
Without a
the
doubt.
information wasn't there. We need to, all of these problems that we've been talking about, if there had been a DUI court available, which there can't be in municipal court, if the GCIC information had been there, because there are still mandatory minimums for DUIs, you have to spend a certain amount of time in jail for each successive DUI. And I do believe in I'm blanking on what the term is. Oh, somebody tell me what it is. Graduated sanctions.
I'm sorry, yeah.
Graduated
It
sanctions.
was right on the tip of my tongue. Wait, 1 second.
No, I'm done. I'm done.
Actually,
That's what it is.
Senator Jackson, do you have another question? And all right, we're running out of time, and I know Senator Robertson and C need some questions too.
Just really quickly, can you all define, when you say repeat offender,
Mm-hmm.
what does that mean exactly? Because I think, you know, we believe in second chances, but not third, fourth, or fifth. I mean, so when legally, when you say you track repeat offenders, what counts as repeat offender?
Well, I'll tell you that was a matter of debate for some time. There was a time period where people, well-meaning, but were defining repeat offenders as people who had been arrested a bunch of times, when in fact there is no definition of repeat offender under the law. There's a definition of a recidivist under the law, which is very clear, and there is no discretion on sentencing recidivists. A repeat offender is a vernacular term, a popular term that just means someone who has been through the system on multiple occasions. And so in major metropolitan cities all over the country, you see people who have been arrested and convicted of misdemeanor larceny or felony breaking into a car or other things like that, multiple times. And it was only after we worked with the Police Foundation and APD that we were able to reach a common understanding that we mean people who have been convicted multiple times of non-serious violent felony offenses. And so really intending to address the quality of life crimes that occur repeatedly and that need to be addressed. And so that's how we arrived at that definition.
And Senator Jackson, if I can give you just a brief example, there is, particularly in the municipal level, you may see the same person every week. I have one person I looked at last week who's been there 36 times within the last few years. And so those are misdemeanor cases. They don't stay in the county, the city. Mm-hmm. We transfer those to the county. And so I'm constantly transferring.
Sure.
Constantly transferring. So, but how do you deal with them? We know for a fact that this gentleman has a mental health issue, and there's nowhere for us to place him to get the assistance. So saying stay away from this location, it doesn't work, because it just doesn't compute to stay away. So So you have that person cycling through, and the economics of that person being jailed, they're not hurting anyone, but it's still a problem. It's still a concern. So for us, we would call that a repeat offender, somebody that's a frequent flyer that we're going to see.
Sure.
And we know within the next few weeks, we're going to see them again.
Thank you. And we're going to get kicked out of this room, so 1 minute, Senator Robertson.
The vast majority of the types of cases I hear where there's bonds concerns, those aren't restricted offenses. The restricted offenses is a very short list. And there's where our concern is that those individuals are being put back out. The gentleman with the weapon that was shown in the video when the presentation was given, I mean, that's pretty clear. He should not have been back out on judicial release.
And he wouldn't be today.
Right. And as far as the Pew study looking at the sentencing of the 80s, where it did show positive were some violent offenses.
Correct. Absolutely.
And
the people we're afraid of,
right,
not
right.
the people
No,
that we're mad at.
You said it exactly right. So I think what we have to be careful of is that we shave down and we're all looking at apples and oranges, that we don't confuse the two. The vast majority of individuals you were discussing, Judge, misdemeanors and stuff like that. I mean, I worked in a large county jail as a 22-year-old. We had a lot of programs, whether it was AA or whatever. The inmates had the choice of going, whether they wanted to move to a faith-based dorm, whether they want to be in a veterans dorm, mental health dorm, stuff like this. So there's solutions out there that do not necessarily need the state intervention more than the community intervention. And so I think there are solutions there when we partner across aisles. But the bond issue, I feel, is very clear. And the overcrowding of the jail is just like the Chief Judge said. I think if you go and look at most overcrowded jails, they are not going to be crowded with the people that we were talking about that are restricted. And also the majority of individuals held in jail that have mental health problems, you'll find the vast majority are nonviolent felonies or misdemeanors.
Thank you. Senator C., 1 minute, please.
All right. I just want to go back to the mental health, because we are hearing on TV they are in crisis and they still being shot. I mean, we got all kind of barriers right there. And I just happen to have been around when we decided to close Milledgeville, which we got so many more crises going on, which is inundating our hospitals because they have no intervention, crisis places to put folk in, and then Popo got to come get them and try to transport them. It's a myriad of issues, but it's mental health that is most concerned with me, because we're having too many deaths regarding folk who have mental illness. Until we address that issue, and it, in my mind, it's starting with the hospitals having, or this is a brilliant idea now.
All right, let's hear it.
We got that whole new wing set up for COVID we hadn't used. We need to start looking at what spaces we have so we can put people who are in crisis somewhere. We spent money. It's down there. It's available. It's ready. We just got to do better as a unit, as a state, if we want to take care of the least, the less, and the lost. Thank you, Mr. Chairman.
Thank you. Your Honors, let me begin or end where I began. Thank you for your time. Thank you for your service and all that you do here. I appreciate your comments. I'm going to ask each one of you to please email directly your specific comments and recommendations so we can capture them accordingly. Again, please help us with solving the problem of following Senate Bill 404. A couple of quick final comments. I want to thank again everyone who spoke today, all the other folks that are here in the audience. We're not going to try and reinvent the wheel, because a couple years ago we didn't have a big problem, right? Some of this is basic blocking and tackling. It started last summer, and the biggest thing we can do right now is support our men and women of law enforcement who are out there every day on the front line risking their lives in order to keep us safe. And I want to say thank you to each and every one of them. And last but not least, again, to my friends in the city of Atlanta, get that jail turned over and get it done now. We don't need bureaucracy, we don't need politics, and we don't need a longer amount of time. We can solve a problem today. Let's work together in the spirit of cooperation and make a meaningful difference for the people that live in our great city and state. Thank you. This meeting is hereby adjourned.
Thank you, Mr. Chairman.